Opposition to a UK trademark. People often ring us up when they receive a note of threatened opposition to their trademark application. So I thought it might be useful to give an overview of the UK Intellectual Property Office's opposition procedure. The UKIPO provides a number of guidance documents about UK oppositions which provide detailed information and advice about all aspects of the opposition process. Rather than duplicating those notes, I want to give you a short overview with web links to the relevant UKIPO information. What is an opposition about? All UK trademark applications are published by the UKIPO for a period of 2 months, extendable for 1 month. Publication allows third parties to oppose registration if they consider the UK trademark shouldn't proceed to registration. There are many grounds on which you can oppose registration. A common reason is that the published mark is confusingly similar to an earlier mark owned by you for the same or similar goods or services. However, you can also oppose a UK mark if you consider that it should not have been accepted by the UKIPO. For example, if the published mark is descriptive of the goods or services, or if it was filed by the applicant in bad faith. For more information on the UKIPO's website about oppositions, go to this link. Outline of the opposition procedure. The main steps in a UK opposition are as follows. Usually, you will contact the applicant asking them to withdraw or limit their application under threat of filing an opposition. Failure to do this may lead you to later losing costs, even if you win the opposition. You can oppose a UK mark by filing a notice of threatened opposition, Form T7. This form sets out your opposition claims. The applicant then has 2 months to reply by filing a defence and counter statement. This is usually a denial of your claim. If a defence and counter statement is filed, each side is given 2 months to file its evidence. First, you have 2 months to file evidence in support of your opposition. For example, evidence of the reputation or use of your earlier mark. Then the applicant will have 2 months to file evidence in defence of its trademark application. When the evidence has been filed, the UKIPO asks if either side wants to have an oral hearing. This is held before a hearing officer, at which you or your lawyers will have the opportunity to argue your case in person. If neither side requests a hearing, the UKIPO decides the matter based on the written evidence and legal submissions which have been filed. Within a few months, the UKIPO will issue its decision, either upholding or rejecting the opposition in full or in part, awarding costs to the winning side. Either side can appeal the decision. What happens before filing opposition? Now, if you or your lawyer become aware of a UK trademark application which you believe should not be registered, it's usual to contact the applicant requesting that they voluntarily withdraw their application in whole or in part. This is important because if you don't do this and you succeed in the opposition, the UKIPO may penalise you on costs, i.e. you may forfeit some of the award of costs. You can extend the 2-month opposition period by an additional month if you apply to the UKIPO before the end of the initial 2-month period. This is done by filing a Form TM7A for which there are no official fees. For more information on filing the form, go to this link. Filing a notice of opposition. Now, notice of opposition is filed by means of Form TM7. The standard official fee is £200. It's possible to go for a fast track opposition and pay a reduced fee of 100 if you can rely on a limited number of grounds. Here's a link for more information about fast-track oppositions. You can claim a number of different grounds of opposition in the standard notice of opposition, TM7. These are divided into two broad categories. Firstly, if you believe the UKIPO should not have accepted the UK mark for registration. This might be because use of the mark is descriptive, generic, a standard term in the trade, or if you believe it was filed in bad faith. These are called absolute grounds of opposition. Secondly, if you believe the registration would be in conflict with your earlier trademark rights or other rights such as a design or copyright, these are relative grounds of opposition. Most oppositions are filed because the opponent is the holder of an earlier trademark, a UK one or EU or international mark protected in the UK. And so they don't want the later trademark to conflict with their earlier one. The standard grounds, relative grounds on which opposition is normally filed are likelihood of confusion. You claim that the UK mark is the same or similar to your earlier mark for the same or similar goods or services, such that there is a risk of confusion among the relevant consumers. Reputation grounds. You claim here that your mark enjoys a reputation in the UK, the EU or wherever, and the use of the mark would take unfair advantage to the detriment of your reputation and distinctiveness. Unregistered marks. Now, if your mark enjoys goodwill and reputation in the UK, then regardless of whether it's registered or not, you might oppose the later UK mark if you can prove use of the UK mark would be likely to cause consumer confusion. In legal terms, that it would amount to passing off. For detailed guidance notes on how to complete the notice of opposition, go to this link. What happens after the notice of opposition has been filed? Well, the UKIPO will transmit the notice of opposition to the applicant, who is then given 2 months to respond by filing a defence and counter statement, Form TM8. If no defence is filed, the UKIPO will reject the UK mark and costs may be awarded to the opponent. If the applicant does file a defence and counter statement, Form TM8, within the permitted period, the UKIPO will forward it to you. For more information on the defence and counter statement, click here, or rather go here. You should have decided to enter into discussions after opposition has been filed, because it's possible to defer the next steps in the proceedings to allow time for negotiations by requesting a 9-month cooling off period. This is requested by both sides before the deadline to file the defence and counter statement by filing TM9C. It's now a maximum of 18 months of extension to the cooling off period can be asked for. For more information about the entire cooling off period, go to this link. The evidence rounds in a trademark opposition. Now, your evidence after the applicant has filed its defence and counter statement, the UKIPO will allow you 2 months to provide evidence in support of your opposition. This factual evidence and not legal argument, a common reason for it might be if your earlier mark is registered for more than 5 years, for example, you'll normally be required to file proof of evidence of the use of your mark in the UK or EU if that's where your mark is registered. For more information on proof of use, go to this link. If you claim a reputation for your mark, then you'll need to file evidence of your reputation in the UK or in the EU if your mark is an EU mark. If your earlier mark enjoys goodwill and reputation in the UK, you will need to file evidence of your reputation in the UK. If your mark is well known, then you'll need to file evidence that it's well known in the UK. Evidence is usually provided in a witness statement, which is a statement of the facts which you rely on in your opposition. Supporting evidence like sample invoices or examples of advertisements is attached to the witness statement as exhibits. Usually the evidence can be filed with the UKIPO by email. A copy must be sent to the applicant. For more detail on the preparation and contents of witness statements, go to this link. For an example of witness statements, bare bones only, go to this link. If, however, your earlier mark is a recently registered trademark, such that your mark isn't yet subject to the use requirements, i.e. the requirement to prove use of marks registered for more than 5 years, you won't need to file any evidence because use in these circumstances doesn't come into it. You simply rely on the legal rights arising from your registration. In that event, you wouldn't file any factual evidence, and instead, you or your lawyers would later just file legal arguments in support of your opposition. The applicant's evidence. Now, the applicant will be allowed 2 months to file any evidence it wishes in defence of its UK trademark application. The UKIPO will forward a copy of the evidence to you or your lawyers. The decision of the UKIPO. Now, after both sides have had an opportunity to file evidence, the UKIPO will ask each side if they would like an oral hearing. If neither wants one, then the UKIPO hearing officer will decide the case based on the documents and evidence that have been filed during the proceedings, and after giving each side the opportunity to file legal submissions. The hearing officer allows a few weeks for legal submissions. The decision will normally issue within a period of 2 months thereafter. If either side requests an oral hearing, the UKIPO will schedule a hearing, which is usually by video conference or a physical hearing in London or Newport. For more complex cases, such as cases with cross-examination, it's common for the parties to actually be represented by a barrister. Otherwise, the parties are usually represented by their solicitor or attorney. For more information on hearings in opposition proceedings, including the oral main hearing, please, here's a link. Cost awards in trademark oppositions. The general rule is that the winning side is entitled to an award of costs. The UKIPO has a scale of costs to decide how much money to award to the winning side. For more details on the award of costs and the scale of costs awards, go to this link. As a brief summary, the current scale of costs awards provides preparation and evidence £500, £200 preparing witness statements and considering a statement of the other side, £650 for preparing legal submissions, £500 for preparing and attending an oral hearing, up to £130 a day. You know, they're very small amounts. Appealing decisions of the hearing officer. Now, either side can appeal the decision to the UKIPO. You can appeal to the appointed person or the High Court. The appointed person is a senior lawyer appointed by the government, and their decision is final and unappealable. Alternatively, you can appeal to the High Court, the judgment of which may itself be appealed to a higher court. For more information on appealing a decision of the UKIPO, go to this link. So the starting point, if you're facing an opposition, is to review this information and then decide whether you want to get an experienced lawyer involved and an opinion on whether or not you prefer to withdraw your application and try for a different name, or whether you will continue during the proceedings.